Judgment in the matter of the Royal Embassy of Saudi Arabia Cultural Bureau against Costantine.
This appeal raises two issues concerning state immunity. State immunity protects states in certain circumstances from being sued before the courts of another state. The rule is derived from the principle of the sovereign equality of states and that one state should not generally be subject to the courts of another in proceedings relating to its sovereign activities. State immunity is a general rule of customary international law. Failure to give effect to it would be a breach of international law. In the United Kingdom, the domestic rules of state immunity are set out in the State Immunity Act, 1978. The first issue which arises on this appeal concerns the duty of a court in the United Kingdom to take a point of state immunity of its own motion when a state is sued but does not attend court to plead immunity. The second concerns the scope of immunity from an employment law claim brought by a member of staff employed by the state's embassy in the United Kingdom. These questions have arisen from claims brought by Ms Costantine against the Saudi Arabian embassy for alleged direct discrimination and harassment relating to her religious belief. Ms Costantine is a dual Lebanese and British national and a Catholic Christian who was employed by the Cultural Bureau of the Saudi Arabian embassy for 8 years, ending in January 2018. The embassy's function during the respondent's employment included looking after arrangements for Saudi students while they were studying in the United Kingdom and protecting their interests. Ms Constantine's employment at the embassy fell into 3 phases. First, she was employed as a post-room clerk in the Administrative Affairs Department. According to the findings of the Employment Tribunal judge, her role essentially involved cross-referencing university invoices against the name, number, and university of various students. She did not make any decisions in relation to this information. She was also involved in organizing the embassy's Careers Day and graduation ceremony. In 2016, Ms Costantine moved into the second phase of her employment as the secretary to the head of the Cultural Affairs Department. In this role, she performed basic secretarial functions. Finally, in 2017, she was transferred back to the Administrative Affairs Department as a post-room clerk until her employment was terminated some 4 months later. Her claims for discrimination and harassment on the grounds of her religious belief relate to various alleged incidents that span all 3 phases of her employment. When Ms Costantine brought these claims before the Employment Tribunal, the embassy pleaded immunity under the 1978 Act. The tribunal conducted a preliminary hearing to determine the issue and held that the embassy was not entitled to state immunity. The Employment Appeal Tribunal dismissed the embassy's appeal on the issue. The Court of Appeal then granted the embassy permission to appeal. However, before the appeal was heard, the solicitors acting for the embassy applied to the Court of Appeal to come off the record on the ground of prolonged non-payment of their bills. The Court of Appeal granted the order and contacted the embassy, advising them to arrange for alternative representation at the hearing. The embassy did not attend and was not represented at the appeal hearing, and the Court of Appeal dismissed the appeal for non-appearance. The Supreme Court holds that the Court of Appeal was wrong to dismiss the appeal without considering of its own motion whether the embassy was entitled to state immunity. Under the 1978 Act, Section 1, Subsection 2, expressly requires courts to give effect to state immunity even though the foreign state does not appear in the proceedings. This necessarily includes a duty of inquiry. If the foreign state does not attend the hearing to argue the point itself, then the court should inform itself about the circumstances of the case in order to decide whether there is an entitlement to state immunity. The duty on the courts to consider state immunity, even if the foreign state is absent, extends to appellate courts. This is clear from the provisions of the 1978 Act, from its purpose, and from the existing case law on the duty in this jurisdiction. In this case, the Court of Appeal was aware that state immunity was in issue, as that was the basis on which permission to appeal had been granted, and it had the benefit of an updated skeleton argument filed by the embassy's solicitors before they stopped acting for the embassy. In those circumstances, the Court of Appeal had a duty to address whether the embassy was entitled to state immunity. Despite this error of law, the Supreme Court dismisses the embassy's appeal. That is because if the Court of Appeal had fulfilled its duty to consider whether the embassy was entitled to state immunity, it would necessarily have concluded that it was not. A foreign state is not immune from an employment law claim brought by a member of their embassy staff in the circumstances of this case. The principles governing state immunity in employment law proceedings brought by embassy staff are set out in an earlier Supreme Court case, Benkabush and the Embassy of the Republic of Sudan. In that case, the court held that in order not to breach the right of access to the courts under the European Convention on Human Rights and the European Union Charter of Fundamental Rights, state immunity had to be limited in scope to that which is required by customary international law. Under customary international law, state immunity is limited to acts carried out by a state in the exercise of its sovereign authority. In general, that means that in relation to claims brought by embassy staff, the embassy will only enjoy immunity if either it entered into the contract of employment with that particular member of staff in the exercise of sovereign authority, or the embassy's conduct of which the member of staff is complaining was an exercise of sovereign authority. Benkabush concerned the employment of purely domestic staff, which the court held was an act of a private law character rather than an act of a sovereign character. Although it did not directly concern technical and administrative staff members like Ms Costantine, the court there considered that in most cases the employment of these staff would also not be an exercise of sovereign authority because most technical and administrative staff perform a role that is essentially ancillary and supportive. The court suggested that there may be exceptions where the technical or administrative staff member's role is sufficiently close to the governmental function of the mission. After that case was decided, the 1978 Act was amended to reflect the principles set out by the court. In this case, if the Court of Appeal had considered whether Ms Costantine's employment was an exercise of sovereign authority in accordance with the Benkabush principles, it would have come to the conclusion, the same conclusion as the Employment Tribunal judge, that it was not. The Employment Tribunal judge applied the law correctly to the facts as she found them. She recognized that the promotion of culture and education can be a governmental function within the embassy. However, she concluded that Ms Costantine was not sufficiently close to this governmental function in any of the phases of her employment. Her role was truly ancillary and supportive in both the post room and as a secretary, and at no point involving any government decision-making. The judge considered the fact that Ms Costantine had access to certain confidential information in each of these roles, but came to the correct conclusion that that did not transform her employment into an exercise of sovereign authority. At all times, she was either not aware that she had access to this information, or she used it only to make administrative arrangements. The embassy raised a new argument before this court that the conduct of which Ms Costantine complains concerns the exercise of sovereign authority by the embassy. The court rejects this argument. Ms Costantine is not seeking reinstatement at the embassy, so the embassy's right to decide who it employs is not restricted in any way. There is also no evidence that her dismissal, or the treatment of which she complains, engaged any sovereign interests such as state security. For these reasons, if the Court of Appeal had considered the issue of state immunity as it was required to do, it would necessarily have concluded that the embassy was not entitled to immunity in relation to Ms Costantine's claims. The appeal is therefore dismissed. The court is now adjourned.